So let's go on. Okay, now we're starting to get into some heavy duty lifting here, hence my caution picture. Okay, you need a causal connection between the government activity and property damage. All right. Now that doesn't mean negligence. So get negligence out of your head. But this is where the case law gets muddled. And it also gets complicated because there are, when you practice inverse condemnation like I do, you'll usually sue for several theories of liability, right? You'll have inverse condemnation, and then in California you're going to have dangerous condition of government property. That's under Government Code 835. Then you'll also have nuisance and then likely trespass. And what you'll see as you start to work up these cases and motions get filed and demurs get filed is a lot of times the case law is overlapping, and sometimes, not all the times, but sometimes defendants come in and they start to misunderstand the law and they start to attack the alternative pleadings and kind of lump it all together, and things just get really, I would say unnecessarily so, but they get complicated. Right? Because again, like I said earlier on, depending on, frankly, what decade you pull these cases, you may think that inverse condemnation stands for a proposition, but then that proposition or that rule was likely overruled by a later case, but not explicitly so. So it gets complicated. Now, speaking to that, the rule generally is that you need proximate cause. That's a negligence term, but you need proximate cause without considerations of fault. All right? So what does that mean? Well, it means that inverse condemnation does not involve foreseeability or fault, analogous to negligence. So traditionally, and what you'll see, we'll get into this, traditionally, when you're dealing with inverse condemnation, the theory of liability is very similar, not on all fours, but very similar to strict liability, right? But we'll see as we continue the CLE, there's arguably been a move away from that and a broadening of this reasonable read negligence analysis when you start to look at these cases. But taking a step back, generally the rule is you need a causal connection between the government activity and property damage. And like I said, that means proximate cause without considerations of fault. All right? Two exceptions to that. One are any actions by the government taken under the police power. All right? And then two, what's known as the Archer exception. This came out, I think it was a Supreme Court case in 1950 or so, that what happened was you had two property owners. You had an upper property owner, owner of the upper parcel. You had the lower property owner, owner of the lower parcel. There was a stream shared by the two of them. What happened was the upper property owner diverted the natural flow of the stream and it flooded the lower property owner. Now, in that case, the court said there's no liability for the upper property owner under water law. And the court said that rule was applicable to government entities. All right, so that's the Archer exception. You'll see some cases, if you start to dig into this, get into Archer. But Archer, I would say, is arguably overruled. It's certainly questionable after another case called Laughlin, which we'll get to in a minute. Now, another case that's important to keep in mind in regard to causation is the Bel Air rule. So that's a case involving damage caused by construction and operation of flood control project. The rule out of that case is when you have damage caused by a flood control project, that the project's failure to function as intended is not enough to impose inverse condemnation liability. So this is, in my opinion, the first time you start to see a step away from the strict liability analysis more into the realms of negligence. So what Bel Air says is in the context of a flood control improvement, if there's been damage to private property as a result of floodwater, you need to show unreasonable conduct by the government entity, right? So it's not enough, again, it's not enough to say, okay, you had a flood control project, things went sour, and now the floodwater escaped and damaged the private property. It used to be that's enough. You'd say that's inverse condemnation. However, Bel Air comes in and says, no, that's not enough. You have to show that the entity did something unreasonable, all right? So the problem, one of the problems with Bel Air is it left unreasonable defined. Well, not so much defined, more like they didn't flesh out that idea, right? What do you mean, court, in this context, in a flood control context? How is an entity unreasonable? How do you show that? That question was answered years later in the Laughlin case, which we just mentioned, and by introducing what are known as the Laughlin factors. So now what you need to understand in the context of flood control cases, the standard is not the traditional strict liability, rather it's the reasonableness standard introduced by Bel Air.